Item C, discuss the petition of the judgment filed on May the 9th in the Superior Court, Mitchell County.
I got a question for that.
Go ahead.
If we were wanting a ruling from a judge on the legality of the county police force, how will an attorney be able to do that without a ruling coming from a Superior Court judge?
No, Mr. Gross, your question is, how could you get a determination of the validity or the legality of the drug task force without there being a ruling from a court?
Yes, that's what we was wanting, was a ruling from the court on the legality of the formation of the county police force.
And that's the question that's presented. I mean, the only way that I'm aware of to really get an answer that is a binding answer to that question is through the court system, and to get a judgment from a court of record. And that is exactly the question that is presented in the declaratory judgment action that we have filed. That was the purpose of filing that. It's certainly nothing against Sheriff Bozeman. I mean, at all. I don't think that this board, in any form or fashion, intended or intends to say anything against Sheriff Bozeman or the position that I understand that he has taken, and alleged on behalf of the board that he has taken in our declaratory judgment action. Because the declaratory judgment action is one that is not so much an action against the sheriff, it is one where he is named as a respondent in order to get the answer to the question that you've just posed. That is the drug task force, was it properly created and legally existing? And I think that the proper method to do that is the one that was done, and that is to file a declaratory judgment action. I hope I've answered your question.
Not really.
I mean, the only way that I'm
my question was, you explained that you had to go through the process with the sheriff.
That's correct, in my view.
But my question is, we still don't have an answer from a judge. And how can you and his attorney sit down and work it out without an order from a judge when we've got one order from a judge that it weren't formally?
Well, Commissioner Curls, as I've explained, while there is language in Judge Lane's order that he issued in that Barfield case, in which he gave his opinion that he didn't think the drug task force was properly formed, that portion of his order was not a legally binding portion of his order. It is what is called dicta, which means it's just language that's in there. It's not appealable. It does not have the force of law. It's not binding on anyone. And as I have explained, that in large part, that language in that order has put the county in the position that it currently finds itself, and that is where we need very desperately to have obtain an answer to this question. Now, when I have mentioned to you and asked just a moment ago for authority to settle this matter, what I'm talking about is, as I said, I think there is much common ground between the two parties, and we would seek to find what we can agree on and make that part of an order that would be signed by a Superior Court judge. In other words, it would not simply be a settlement agreement and dismiss the lawsuit. The answer would be found in, if things work as I hope they will, in an order on which both the parties could agree, and in which a Superior Court judge, we would hope, we would present to the judge and hope and believe that he would sign it. So there would be an order from a Superior Court judge At least I'm hopeful we can arrive at that. I don't know that for certain. But I'm hopeful we would be able to arrive at a consent order of some fashion, which a judge would also sign, and which would then be binding on the two parties. It is not simply what I would envision and what I hope to obtain the authority to do is to discuss this matter with the sheriff's attorney, and as I said, find the common ground that I believe that we do have, because there are a lot of things that this board and I think the sheriff would certainly agree on, and find that common ground and utilize that to form a consent order which both parties could be happy with, and which the Superior Court judge would be willing to sign. That is what I'm asking for the authority to do. So it's not simply an agreement between the two parties or the two parties' attorneys. It would be something that would be presented to a Superior Court judge for that judge to sign off on.
And you're gonna keep us well informed at all times of what is being going on.
Well, there are several reasons why it might be. One, of course, is that I think that Commissioner Snipes' motion was contingent upon a resolution of this by the 31st. That was the nature of his motion. So to that degree, his entire motion was contingent upon there being a resolution of that declaratory judgment action. So to that degree, it is very valid. The other thing is that there are questions which Judge Lane's order places a shadow on actions taken by the Drug Task Force in the past, which need to have some resolution to them, or some hopefully favorable answer given, so that can better protect the county and law enforcement generally, and the cases previously made by the Drug Task Force from attack either directly or collaterally. That's why, I mean, it is somewhat relevant because of those reasons.
Any further discussion?
After you said that, I make a motion to authorize the county attorney to settle the declaratory judgment action involving the legality of the South Drug Task Force, Mitchell County versus Sheriff W. Bowes.
And that authority would be consistent with that I had discussed with each of you individually and have provided you with some other information individually. Is that correct?
Yes.
Then both votes second. Then further discussion. If not, ready to vote. 1, 2, 3. 4 votes in against, 1 vote against. Motion passed 4-1.